From the Punjab Medical Legal Agency, this is a practical, system-based guide for handling the medical legal aspects of sexual violence cases. Our focus isn't on legal theory, but on the real-world operational protocols that you need to protect both the survivor and yourself as a clinician.
This quote, well, it defines the reality for every practicing doctor. And when it comes to cases of sexual violence, that distinction is absolute. A clinical mistake might be understood, it might be forgiven, but a medical legal one, that can completely shatter a survivor's chance for justice and, at the same time, expose you to serious litigation. Getting this right from the very beginning is the most important step you can take for your own professional protection.
So in this session, we're not going to be reviewing legal statutes chapter and verse. Instead, we're going to give you the system, the standard operating procedure that prevents the common and, frankly, often career-threatening mistakes that we see in hospitals and courtrooms every single day. So let's begin. The first and, I'd say, the most common medical legal trap is a fundamental misunderstanding of what consent really means in these specific cases. It's often the initial point of failure where so many other errors begin to cascade. It's absolutely crucial to understand these are two totally different legal concepts. They carry different weight. You see, consent for medical treatment, that can often be implied when a patient comes to you for care. But medical legal consent, that can never be implied. It has to be explicit, it has to be informed, and it has to be documented for a very specific purpose, the judicial process. Confusing these two is the first major mistake, and it creates an immediate vulnerability for you and for the entire case.
So here's a four-step process that is absolutely non-negotiable. You have to follow this every single time. First, you explain the purpose. This exam is to help a legal investigation. Second, you detail the procedure. Tell them exactly what you'll be collecting. Third, you have to affirm their right to refuse any part of it and make it clear this won't affect their medical care. And finally, you explain the duty of police intimation. This is your legal obligation to inform the authorities, even if a first information report, or FIR, hasn't been filed yet. This system makes your consent process legally watertight.
Okay, once you've got that consent secured, your written record, that becomes the next high-risk area. A courtroom is not interested in your clinical interpretation. It's not interested in your personal opinion. It demands objective facts. The record you write today has to be able to stand on its own, under intense scrutiny, sometimes years down the line.
This is a cardinal rule. Think of yourself as a scribe, not an editor. You're not there to summarize or paraphrase. You are documenting direct testimony. The survivor's own words, recorded verbatim, carry immense evidentiary weight. It's one of the most powerful parts of your report.
Let's be perfectly clear on this. These practices aren't just outdated. They are unscientific, they are legally indefensible, and they have been explicitly barred. The so-called two-finger test is a form of assault, period. Any comment on past sexual history or using prejudicial terms like habituated is absolutely forbidden. And subjective notes about a survivor's build or their behavior, they have no scientific basis and zero place in a medical report. Including any of this will discredit your professionalism and could tank your entire testimony.
Your guiding principle here is simple: objectivity. Your record has to be a factual account. So you describe an injury with precise measurements, a 2-centimeter abrasion, not vague terms like large or small. You number every single finding on the body chart and you describe it in your notes. And remember this above all, you never conclude whether rape occurred. That is a legal determination, it is not a medical one. Your only job is to provide the objective evidence the court will use to make that determination.
All right, let's shift gears to the physical evidence itself. This is often the cornerstone of a prosecution. And a single mistake, a single procedural error in how it's collected, packaged, or transferred can make it completely inadmissible in court, no matter how compelling it is.
The chain of custody isn't some abstract idea. It's a physical, documented reality. Just think of it like an unbroken log that details every single person who handles a piece of evidence. And here's the crucial part. That chain does not start at the police station. It doesn't start at the lab. It starts with you, right there in the examination room.
The Sexual Assault Forensic Evidence Kit, we call it the SAFE Kit, is the standardized system designed to prevent these kinds of errors. Every clinician needs to be familiar with what's inside. It is everything you need for a methodical collection, from the swabs and vials right down to the paper bags and sealing wax, which are absolutely critical for preserving the evidence and maintaining that chain of custody.
Now, these 5 steps are non-negotiable. 1. Collect your samples. 2. Air dry all biological material. This is so important. Sealing wet evidence in plastic will completely destroy it.
3. Pack each item separately. This is to prevent any cross-contamination. 4. Seal each package securely with that tamper-proof wax. And finally, 5. Document the transfer of custody. This meticulous process is the only way to ensure the evidence you collect is viable and actually admissible in court.
So now we get to the culmination of this whole process, how you formulate your medical opinion. If you followed the protocols for consent, for documentation, and for evidence, you've built the foundation for an opinion that is defensible and will shield you from legal challenges. This framework gives you the correct, cautious, and legally precise language for your provisional opinion. That's the one you issue while you're waiting for the Forensic Science Lab or FSL report. Just notice the phrasing, suggestive of. We only state what we observe. We don't offer big definitive conclusions. And when injuries are absent, we explicitly reserve our final opinion until we get those FSL results. This language isn't just medically accurate, it's legally defensible.
And this brings us to what is maybe the most critical teaching point of all. An absence of physical injury is not evidence of consent. It's a medically neutral finding, and your report needs to state this clearly. The guidelines actually empower you to list the potential reasons for a lack of injury, which helps educate the court and stops them from misinterpreting your findings. Your job is to report the facts, and the fact is, violence doesn't always leave a visible mark.
There is one last step in this protocol. The survivor has a legal right to a copy of all their medical and medico-legal records. Giving it to them isn't optional, it's your duty. This simple act of transparency empowers the survivor, and it formally completes your medico-legal responsibilities for this case.
You know, in the end, this isn't just about individual checklists. This is really a call for institutional preparedness. A strong, clear, and consistently implemented standard operating procedure is the ultimate defense against medical legal error. It protects the patient, it protects the clinician, and it upholds the integrity of the entire judicial process.